This Callais Supreme Court decision today, it hit me in a way that's hard to fully put into words. Not just as an American, but as a black man from South Carolina. Because where I come from, we've seen this story before. And when you've seen something before, when you've lived the consequences of it, it doesn't feel abstract. It feels real. It feels close. And this feels dangerous. People ask me, why do I feel so strongly about this Roberts Court? And I've said it before, but this Roberts Supreme Court may be the Taney court of our time. Not because it's identical, but because of the mission. Preserving power for the few and stripping away the tools that make equal citizenship real. You know, folks talk about voting rights and redistricting like it's some legal theory. But in South Carolina, this ain't theory. It's history. There was a time right after Reconstruction when South Carolina was one of the most politically powerful places for black folks anywhere in this country. We had a black Speaker of the House. We had a black lieutenant governor. We had a black attorney general. We had a majority black legislature. And yes, at one point, most of our congressional delegation was black. Folks, that wasn't symbolic power. That was governing power. And then it all disappeared. Not because people changed their minds, not because black folks stopped showing up. It disappeared because the rules were changed. Poll taxes, literacy tests, violence, intimidation. A system that learned how to look neutral while operating unfairly. And within a generation, black political power in South Carolina went from dominant to almost non-existent. That's why the Voting Rights Act of 1965 mattered so much. It wasn't charity. It wasn't politics. It was medicine. It was the intervention that said, no, we are not going to let states rig the system and call it democracy. It forced fairness. It created accountability. It opened the door back up. And because of that, almost 100 years later, we got African-American leaders across the South like Jim Clyburn into Congress. But what the Taney Court did in one sweeping moment, the Roberts Court is doing step by step. Not with one shocking decision like Dred Scott, but by hollowing out the protections that made progress possible. If you think this is just about voting rights, you are missing the pattern. You see it in the rollback of women's reproductive freedom in Dobbs versus Jackson. You see it in the dismantling of long-standing protections like Chevron deference. You see it in the elevation of corporate power in Citizens United. And you've even heard it from the bench when Justice Clarence Thomas has suggested revisiting rights many Americans thought were settled, including marriage equality. Folks, this isn't random. It's a direction. And when it comes to voting rights, the steps have been clear. Shelby County took away the ability to stop discrimination before it happens. There was another court case that made it harder to challenge losing those rights after the fact. And now decisions like Callais raise the bar so high that proving discrimination becomes damn near impossible. So let me say this plainly. You don't have to ban the vote anymore. You just have to make discrimination impossible to prove. And that's why I'm unnerved. Because I know what happens next. We've already seen it. Some of these southern states aren't waiting. They're already moving, redrawing maps, shifting lines, consolidating power, and not loudly, but some of them loudly, in ways that they are making headlines. But this can be slow and systematic. But in essence, we see the decimation of black representation. So when people ask me, is this really that serious? I tell them you need to go back to learn your history. Because there's something very simple about this. The Voting Rights Act was the medicine that treated a very real disease in our democracy, a cancer in our democracy. And the question right now is this. If you stop taking your medicine, do you really believe the cancer won't come back? South Carolina already answered that question once, and the answer was yes. So what do? We don't panic, but we sure as hell don't sit still. Because if the courts are stepping back, then we the people have to step up. That means organizing locally. That means investing in these southern states. That means candidate recruitment, real recruitment in every district, every county. Because power doesn't just disappear on its own. It gets taken when nobody is in position to fight for it. We have to mobilize. We have to compete everywhere. We have to build benches of leaders who understand what's at stake, not just for today, but for the next generation. Because this moment right here, it's not just about a court decision. It's about whether we remember our history well enough to not repeat it. The Taney court slammed the door, but this Roberts court is quietly taking the hinges off. And I'll tell you this, where I come from, we've seen what happens when the protections go away. We've seen how fast power can vanish. So no, I'm not overreacting. I'm remembering, and I'm telling you, we better act like we remember too.